Laboratories UK Limited and others, and Warner-Lambert Company LLC and others, Part 1.
Yes, Mr. Bolton.
My Lords, eating slightly into the second day, I have 4 matters left over from yesterday. The first arose out of yesterday, and that is that we have filed and served on the inquiry claimants an application notice to amend our grounds of appeal.
Right, well that hasn't reached me. I don't know if my Lords have had it. No.
I think by oversight, my Lord, we failed to file it with you, but
All right.
if I was able to hand it up. It's,
Yes, all right, we've got to have it now.
And for where we were, second, I was going to say something brief about Virgin. Thirdly, conclude my submissions, which is about 2 minutes. And then fourthly, which you will all be looking forward to, my learned junior, Mr. Austin, will address you briefly on infringement.
Very good.
If
Yes, can we have that document, please? Thank you very much. Thank you.
Apologies that it didn't reach you, my lord. It was served on the inquiry claimants at 6 o'clock last night. I don't know if it's helpful just to allow you to look at it, or I can talk you through it. It's straightforward.
I don't think it's right to say that we encouraged you to make this application. I think the position is that we said if you wanted to run the point, you would have to make an application, which is slightly different.
Which I treat as encouragement to make the application, not to say you will grant it, my lord.
Okay. Let's read it. Yes. All right, well, do you want to say anything further about that now? It seems to me you've probably made most of your points about it
I think,
yesterday.
my lord, I think I have made all of my points about it, other than to say that we did go back to the transcript of the hearing before Mr. Justice Zacaroli, and at the outset, on day 1, I raised the pleading point with relation to what was actually 45A, which I did show your lordships yesterday of the defence, and then in subsequent argument on day 3, it was Dr. Reddy sought to strike out 4 or 5 paragraphs from our points of defence, which included all of the paragraphs at issue 45A and the ones referred to in this proposed amendment, my lord.
All right, well, rather than deal with the application now, we'll simply hear what Mr. Nicholson and Mr. Campbell have to say about it in the course of their submissions.
Of course, my lord. If I may also hand up briefly, I'm not sure if the lordships need this, but I think it would be helpful to hand up Virgin, because I was asked some questions about a paragraph of our skeleton that extracted only one passage from the Virgin Authority. So if I may hand up also this. I'm full of apologies, my lord. This is not hole punched, but I do the best I can on my feet.
Well, it's not only not hole punched, it's not the report, which is the way that cases ought to be presented when they are reported.
Indeed, my lord, which my lord, I was working off what I think was the right Can I proceed at least by reference to the relevant paragraph?
Yes,
Or would you
let's.
prefer me to do it properly?
Yeah, no, we'll have to work with this as it's what we've got, but you tell it takes the right paragraphs.
Thank you, my lord. The starting point within Virgin Atlantic Airways and Zodiac seats, I referred the court yesterday, but without showing you, was that in paragraph 17, which on the copy I was working from was at page 180 of the authority at 180G, but it may be that your lordships have to find paragraph 17 in your...
It's on page 9 of what you've given us.
I'm grateful, my lord. And this is the paragraph where Lord Sumption says at the beginning of the paragraph that res judicata is a portmanteau term. He goes through a number of principles, and as I mentioned to your lordships yesterday, at the end of paragraph 17, the last few sentences, he says, fifth, there is the principle first formulated in Henderson and Henderson. And so he is here treating it as within the portmanteau term for res judicata.
But his whole point here is that as a label, it's utterly unhelpful because, as he says, it's applied to different legal principles with different juridical origins. His whole point is you need to distinguish between these.
Well, my lord, we were relying upon this to submit what I hoped was not controversial, which is that Henderson abuse is a matter of substantive law. It's a rule of substantive law rather than simply being a procedural rule.
I haven't understood that. Sorry. Henderson and Henderson abuse is a form of abuse of process, and it's part of the ways in which courts control the process before them. Why is that not procedural law?
Well, what Lord Sumption says, my lord, is that essentially it is both. But we rely upon what he says to say it's not simply procedural. Perhaps if I can show you in a couple of places, and then if I'm failing to answer the objections from your lordships, you will, of course, tell me. At paragraph 19, he reiterates the point that it's the commonest form of res judicata. In 23, it was argued, apologies, that it's 184 of my authority, but paragraph 23, it was submitted to us, Lord Sumption says, on behalf of Virgin, that recent case law has recategorized the principle in Henderson and Henderson so as to treat it as being concerned with abuse of process and to take it out of the domain of res judicata. And at the beginning of paragraph 24, Lord Sumption says, I do not accept this. So yes, it's directed against the abuse of process, but he then cites within the main body of 24, Lord Bingham in Verwag, formerly Messina and Smith, where it has much in common, Lord Bingham said, with cause of action estoppel and issue estoppel. And within that paragraph, the emphasis is on the bringing of a claim or the raising of a defence. And we rely on that here because what we are seeking now to do is to raise a defence to a claim for damages under a cross-undertaking. And that
Mr.
is
Bolton,
not a
I'm sorry
defence.
to interrupt you, because you haven't yet got to the key passage, which, as we debated yesterday, was one you had actually quoted yours as an argument, and it's the passage of paragraph 25, where, having been through the case law, Lord Sumption's conclusion in the middle of the paragraph, as we discussed yesterday, is that res judicata and abuse of process are juridically very different. Res judicata is a rule of substantive law, while abuse of process is a concept which informs the exercise of the court's procedural powers. So why is that conclusion not against the proposition you're presently advancing?
Well, that's why I was seeking to show you the build-up to paragraph 25, which is the next paragraph we come to. Because as Lord Sumption says at the beginning of the paragraph, it was clearly not the view of Lord Millett and Johnson and Gore-Wood that because the principle in Henderson and Henderson was concerned with abuse of process, it could not also be part of the law of res judicata. And so what Lord Sumption is saying here, respectfully, my lords, is that Henderson and Henderson is concerned with abuse of process, but it is still, quite clearly, he has concluded in the paragraphs I've shown you, a part of the law of res judicata. And therefore we say it's a matter of substantive law, rather than simply being put in a procedural tool available to the court. And if it's a substantive tool, then akin to other forms of estoppel, it's a personal right, and Dr. Reddy's can't rely on that estoppel where it was not a privy. But that was as far as I was trying to take the point, my lord, and I think the confusion arose because the extract that we put in our skeleton suggested that Lord Sumption was saying these are very different. He is saying they are juridically different in terms of where they come from, but he is also saying that Henderson and Henderson abuse is part of res judicata.
Right.
I'm grateful, my lord. At the end of yesterday, my lord, I had reached ground 2, which is a simple and straightforward point, which is that we said that the arguments here raised a novel point of law, and one has seen from the way that the parties here are seeking to rely on the authorities that there has been no decision squarely on the points that we are raising in the context of our amendments, particularly on just and equitable grounds. We also say in our skeleton that there are a large number of factual disputes that ultimately will inform the trial judge's exercise of his discretion if it gets to the trial judge for this. For example, we know very little about exactly how the NHS Scotland reimbursement schemes under Part 7 of the Scottish tariff would have worked. There has, I think, been some disclosure on that recently, but there is a lot to unpick. There is the factual investigation as to the actual effect of the guidance order on prescribing, and Dr. Reddy's will have to make a case on what the actual effect of the threats was, and there will presumably be some evidence on the actual size of the market for treatment of inflammatory pain.
Sorry, Mr. Bolton, I'm not understanding. I appreciate, of course, that there are these factual matters to which you refer, but you told us yesterday, I thought, unless I misunderstood, that you were inviting us to decide the issue of law.
Yes, my lord.
In which case, all parties before the court are inviting us to decide the issue of law. And in those circumstances, how does ground 2 operate?
Well, ground 2 was put forward, my lords, as that it raises a novel point of law.
To be sure.
And
it's a reason for not deciding it.
And I rather late yesterday conceded that as a novel point of law, it was for this court to determine that issue. But ground 2 was also that the ultimate success of the amendments might turn on disputed facts that will need to be determined. So clearly, to the extent that there's an argument about this is a novel point of law, we're saying the judge at first instance should have allowed it on the grounds it was a novel point of law. But of course, this court, as I said yesterday, can decide that point of law. But we highlight also that there are disputed factual issues that mean if your lordships agree with us that there is an argument here that fairness and equity can be taken into account on damages under the cross-undertaking, then how that plays out will depend on facts that are not before this court. So it's just a two-stage, and I'm not seeking to stop your lordships from determining the point of law.
Once we've done that, it won't be a novel point of law anymore, it'll be a decided point of law.
Indeed, my lord.
And you'll either be right or wrong.
Yes, my lord.
Yeah, okay.
But giving the ground, because the ground was the judge should have allowed this because it was a novel point of law. Of course, my lords, you can now determine what that law is.
Yes. All right.
One difference about NHS Scotland, about which I said very little yesterday, NHS Scotland does not have a claim under the guidance order, and its damages claim is different from and slightly more complex than Dr. Reddy's. Dr. Reddy's are comparing the actual world with the counterfactual. NHS Scotland are doing the same, but the counterfactual world involves a determination of what could or what should or what would have been done to recategorise pregabalin, and therefore what proportion of total use would have been reimbursed at the higher patent price, or as NHS Scotland claims, it would all have been reimbursed at a much, much lower price. And we say that NHS Scotland should have paid the higher patent price for the patented product, and any reimbursement of pregabalin that was used for inflammatory pain should be deemed to be at the original patent price rather than at the later reduced tariff. That's if they succeed on their argument that the tariff would have been reduced.
So in relation to NHS Scotland, your case is not, as I think it is with Dr. Reddy, that they simply take a 13.8% haircut. I think you describe it. It would be this rather more complex exercise.
On their case as pleaded, my lord, our claim is that the proportion of pregabalin in Scotland that was prescribed for inflammatory pain should be treated to have been reimbursed at a higher patent price. And if 13.8% applies to Scotland as well, then we would be seeking to apply the same 13.8% haircut. So it works in the same way, it just applies to a different calculation of damage.
But in their case, the counterfactual as to what would actually have happened in the counterfactual is that the price for pregabalin would have come down earlier, and that price would have applied across the board, regardless of the purpose for which any particular pregabalin was prescribed.
Yes, my lord, but it's the same two-stage process, which is that their claim is that as a matter of causation, but for the orders that they say were wrongly made, then pregabalin would have been reimbursed at much lower prices from much earlier dates. And that's the first stage of damages under the cross-undertaking and what loss is caused by the orders. And we say the same principles should apply to the second stage, which is what compensation should NHS Scotland be granted, be given, be awarded. And that should take into effect that some of the prescriptions were for inflammatory pain, which was covered by the inflammatory pain claims that we say were valid. And so we say it applies in the same way, my lord.
Yes, I see.
My lord, if unless I can help you further, perhaps Mr. Austin, my learned junior, can address the court. And for purposes of being seen, heard, and on the microphones, perhaps I can ask him to come forward already.
Yes, by all means.
Lords, as has been well trailed, I'm going to address my lords on infringement by pharmacists. I'll develop each of these points as I go along. In summary, the issue as to pharmacists dispensing a product for the treatment of inflammatory pain, we say has a number of significant differences to what was decided by the courts in the activist proceedings. In these proceedings, we advance the point under Section 61B of the Patents Act 1977.
Well, sorry to interrupt you. when you're only just getting underway, but can I be clear? Are you relying solely upon Section 61B, or do you have any alternative case?
Well, that is our primary case, my lord, but also we would seek to rely on Section 60, subsection 2 in the alternative, though I appreciate there are slightly different considerations in that respect.
So do I understand from that that you are not relying upon Section 61C?
That's correct.
Thank you.
And we say that Section 61B, the use of the process of the Swiss claims and patents, was not considered before by the courts in previous proceedings. And indeed, the Supreme Court in the activist proceedings was primarily concerned with defining its test for infringement based on policy considerations in relation to infringement by generic manufacturers. Actually, on the facts, they were marketing authorization holders in the UK. The manufacturing was most likely carried on outside the UK. But that case, as my Lord Justice Arnold has indicated, was a case run under Section 61C primarily and subsection 2. The issue of infringement in the activist proceedings therefore concerned the marketing authorization holders, whereas in contrast, in this case, we say the process of the claims is carried out by pharmacists, for the reasons I'll come to shortly. The tests for infringement, again, just going to the activist proceedings for now, were obiter, and that's because the relevant claims of the patent were held to be invalid. And also in these proceedings, the use for inflammatory pain is for off-label use, rather than what is called the cross-label use in the activist proceedings, and I'll come back to that as to what those are. And we foresee factual differences in the analysis of infringement. So we urge, my lords, upon this court real caution in applying the findings of the activist proceedings to these proceedings. And in due course, it will of course be for the trial court to assess, in the context of the counterfactual tool, making all the necessary adjustments, all the facts in relation to pharmacists. Until one knows the facts and the appropriate legal test, we say it's just not possible to say that the claim for infringement against pharmacists is without merit. We say it's arguable.
Well, there's a fundamental problem with that proposition, isn't there? Which is that while it's obviously true to say that the facts have not yet been found, the first question is what facts you rely upon in support of the claim for infringement. And when we look at the plea, there are none.
My lord is right, and to a degree the test that will be applied by the courts in due course also educates which facts are required. And
nonsense. It's for you to plead the facts that you rely upon, and you haven't done so. There's a total absence of particulars. It is a one-line assertion. No facts at all.
My lord is right about that. We just have in mind that, for example, in the act...
How can you have permission to amend to introduce an allegation with no facts pleaded to support it?
Well, we haven't had any requests from the other side as to expand on exactly how infringement arises. In fact, my lords, the issue of infringement...
Well, you had a request now from the Court of Appeal to explain your case.
My lord is right. I'm not sure that's something I can necessarily advance on my feet, certainly, as to all the facts that are relevant. And of course, it also depends on the relevant tests that will be applied in due course.
Well, can I just... Sorry, go ahead.
I was just going to say, do you know what your case on the legal test is?
Yes, my lord. It's
Yes.
The pharmacists are infringing by the use of the process under Section 60, subsection 1B, and that they are using the process in the course of dispensing generic pregabalin. Let me just, if I could wind back, my lord, and just set the scene in terms of how the system works. The lords are probably already conscious that pregabalin was authorised for general anxiety disorder, epilepsy, and neuropathic pain. The original conditions treatable by pregabalin and for which it was authorised were general anxiety disorder and epilepsy, and it was later appreciated that pregabalin could be used to treat pain, and that's what led to the patent, which was filed in July 1996. And pain generally was covered by the patent, not just neuropathic pain. We'll come back to the claims rules, but the claim 1 is for pain, claim 2 is for inflammatory pain, claim 3 is for neuropathic pain. And then there are further subclaims for subtypes of those conditions. For example, claims 10 to 12 are recognised types of peripheral neuropathic pain, trigeminal neuralgia, postherpetic neuralgia, and causalgia pain. So, notwithstanding that Warner-Lambert, I should say that Warner-Lambert I don't think was the original applicant for the patent, but nonetheless it acquired it at some stage. Notwithstanding that it had a patent for pain generally, for reasons that I'm afraid I don't know, its pregabalin product called Lyrica was authorised for neuropathic pain, as well as general anxiety disorder and epilepsy. So neuropathic pain is the on-label use, but inflammatory pain was and still is an off-label use. And in fact, pregabalin is prescribed off-label for quite a few conditions, and that was in fact covered by my Lord Justice Arnold in his trial judgment at paragraphs 399 to 400. I don't think we need to go to that right now. Doctors may prescribe a medicine for off-label use, and that's often subject to certain prescribing guidelines. And we know that a substantial proportion of pregabalin was prescribed for inflammatory pain. In fact, there's data one can investigate, which comes perhaps from the NHS or indeed from private companies, which shows what the doctors were prescribing the product for. And the evidence, as recorded in the Sandoz judgment of my Lord, was at 13.8% was the figure in evidence. And that's at Authorities, tab 7, 366, page 366 at para 29 of that Sandoz judgment of my Lord. That may be different nowadays, and indeed that was a judgment in around 2015.
No, it was 2016.
2016, no, I'm sorry, my Lord is absolutely right. But the scope of the dates of this inquiry go further, and they go up to around 2018, in fact, depending on the scope of the claim. So this could be a very significant amount of money indeed. The proceedings between Pfizer and Actavis concerned what's called cross-label use. In other words, where the generic pregabalin product said to infringe, which was called Licaint, was only formally authorised for general anxiety disorder and epilepsy, but it was not authorised on its face for neuropathic pain. And that's despite the fact that Pfizer's product, called Lyrica, was authorised for all 3 indications. And that's permissible under the Medicines Directive. The generic manufacturer may apply for marketing authorisation, which carves out the patented indication. And this leads to what is being colloquially called a skinny label. So Licaint was not formally authorised for neuropathic pain, as I said, even if a substantial amount ended up being used for neuropathic pain. And that was part of course, the issue on the facts in the Actavis proceedings. And that's because of the way the prescribing dispensing system works, and that's often usually called cross-label use. Off-label use is somewhat different. Pfizer has not gone through the authorization process to show that pregabalin should be used for inflammatory pain, and hence generic products would therefore be unable to piggyback in their own applications on that data to obtain generic authorizations in respect of inflammatory pain. But nonetheless, the oddity perhaps in this case is that Pfizer had a patent for inflammatory pain. Both Lyrica and generic pregabalin could and would likely, we say, be used to treat inflammatory pain because of the way the dispensing system works. Now, just before getting onto that system, if I could just show the court the patent. I'm sorry, we have been to this, but it's at sub tab 1. Supplementary. And it's at page 6. And as my learned friend, Mr. Bolson, said yesterday, the claims are in what's called Swiss form, which has a basic structure here. The use of, and the Lord sees the chemical name in claim 1, that's pregabalin, for the preparation of a pharmaceutical composition for treating, and then, of course, claim 1 says pain, 2 inflammatory pain, 3 neuropathic pain, and so on. So these are process claims, and they are a preparation of a composition. And the magic word that creates substantial amounts of debate in this case is the word for, as in for treating. Now, as my learned friend said, these have a long history. They're described as judicial fudge. And the explanation of Lord Justice Arnold and Lord Sumption as to how we got here with these types of claims was obviously set out in their respective judgments. If I could just go to the Supreme Court judgment, and that's Authorities tab 5, and it's page 260. And my Lord Sumption, Lord Sumption explains in paragraph 1, I'm just focusing on the second sentence, an important objective in modern pharmaceutical research is the discovery of new medical uses for known molecules. And I'll leave my lords to read the rest of paragraph 1. You see the difficulty with Swiss form, or which led to granting of Swiss form claims, is that you cannot have a patent for a method of treatment of the animal body. Section 4.2 of the Patent Act. In paragraph 2, Lord Sumption explains that some time ago, in 1984, the Swiss Federal Intellectual Property Office issued a statement of practice that it would be prepared to grant patents for second medical use patents. And then my Lord sees the decision in ISI in that same paragraph of the European Patent Office. And the quote from paragraph 23 of that judgment, legitimate in principle to allow claims directed to the use of a substance or composition for the manufacture of a medicament for a specified new and inventive therapeutic application. So no one's, I think, in any doubt that what is the advance, the contribution in this case, is the new use for the known substance. It's not method of manufacture itself.
Mm-hmm. But nevertheless, it remains the case that the process is a process of manufacture, and that's central to the reasoning later in the judgments.
I agree, my Lord, subject to the proviso that in this case it was a process of preparation, which I don't know whether there'll be a difference in the wording, but that was the wording.
Well, it's preparation for a purpose, isn't
Yes.
it? And that is a necessary element of each of the claims.
Yes.
And therefore there can be no infringement unless the drugs in question have been prepared for a purpose which falls foul of a claim.
Yes.
So who prepares the composition? The manufacturer, Dr. Reddy. It's not the pharmacist who prepares the composition, is it?
I'm afraid
Unless you're going to say that by sticking a label on, you prepare the composition. And if that is your case, it doesn't appear to be pleaded, and you would need to explain what is the magic of the label. What does it actually say, for example? Which means that the result is that the pharmacist is treated as preparing the composition.
Could I take my lords to the Court of Appeals decision?
Before we do that, can I just ask you to answer my Lord's question? Is it your case that when the pharmacist sticks the label on the box, he is or she is preparing the composition?
Yes.
Why is that not directly contrary to what Lord Sumption said in paragraph 88 of his judgment, right at the end, in which he refers to Lord Justice Lloyd having considered that the preparation might not be fully put into effect until the pharmacist had dispensed the medicine and affixed a sticker. And Lord Sumption says, in my view, Mr. Justice Arnold was right about this. He took a different view. And not only does he say that, but Lord Reed agrees with him, and Lord Briggs agrees with him, and Lord Mance agrees with him. So why is that not conclusive against that argument?
That, my lord, was in the context of section 60, subsection 2.
But the word preparation doesn't change its meaning, whether it's in section 60, subsection 2, or in section 60, subsection 1b.
It was in the context of the claim. The judgments are very clear that this is really a question of construction of the claim as a prior question before you even get to section 60 of the Patents Act.
I think the simple answer is this is an obiter statement of the approach to infringement.
So a statement that at least 4, if not 5 members of the Supreme Court have made when dealing with section 62, whether obiter or not, is something that you can invite the trial judge to depart from?
I can well see that the trial judge would be unwilling to depart from that in light of that. But were this, for example, to reach the Supreme Court again, and in light of, which would no doubt be heard by, for example, Lord Kitchen, who had a very different view of the test for infringement in his decision in the Court of Appeal in those proceedings. And in respect of the different product, we say Winners cannot form a concluded view at this stage that the case for infringement by pharmacists is without merit.
Going back to your answer that the fixing the label means that the pharmacist does prepare the composition, does that depend on what the label says?
We say in the first instance it doesn't.
So it could just say pregabalin.
For Mr. Austin, take 3 times a day.
And that's enough. That's enough. Right.
Because
So it's not tied to, for example, to be taken for the purpose of inflammatory pain, because generally the pharmacists don't know that.
sometimes it does say that, and sometimes it doesn't. But we say.
But your case does not
cases
depend on that.
It's not doesn't depend on that.
No, okay.
And that the affixing of the label amounts to a process of preparation, which is the ascription of purpose to a specific box of pregabalin. And if I make,
But hold on a minute. Let's assume the label says nothing about the indication. How is the mental element satisfied on your case?
because the intention, if assuming we're on a test of subjective intention, would have been formed with the prescriber, who knows full well, of course, what it is for. In many cases, also.
But the pharmacist doesn't know what is in the mind of the prescriber.
That is true, but we say that doesn't matter necessarily on the test, because there's still an intention of purpose, which is attributed by the prescriber, which is perfected by the act of the pharmacist.
This is completely incoherent.
In other cases, my lord, the pharmacist will know. If I could just take my lords to the findings of fact.
But you see, this is the problem with the fact that your case is completely unpleaded, is because we're asking these questions, and in response to our questions, your case is coming out in dribs and drabs, if I may use that expression. And I appreciate, we're putting you on the spot, and we're not intending to make your life difficult. The problem all starts from the fact that none of this has been pleaded. If we had a pleading, we could look at and see how it was pleaded and see what you were relying upon, and half of these questions could have been avoided.
Lord, could I just? It's at 37A, I think is the capital A of. It's just at.
Sorry, 37A of what?
Or page 167.
Sorry, what are we looking at? Pleading.
This is a pleading.
I thought we were looking at page 188, aren't we?
167.
Oh, is it? All right.
This was our pleading in relation to threats, which was eventually rejected by Ms. Justice Zacaroli. But this explains the basis on which we say that pharmacists would infringe by the dispensing of non-lyric pregabalin products.
This is a claim under section 61C, isn't it?
I think that must be right. Yeah.
Dispose of, offer to dispose of, etc. product. But your claim against the pharmacist is a different claim. It's a claim under section 61B, which is that they're using a process.
Yes, well,
The process is the preparation. Speaking for myself, I now see all 5 judgments in the Supreme Court saying that the process of preparation is not concerned with what happens to the medicine after it's been manufactured, but with the process of manufacture. Whether that's strictly obiter or not, I find it impossible to think that a different view could be come to in this case.
if Bob, I could just hand up the Court of Appeals judgment.
Just before we get to that, you were trying to enlighten us as to the facts relied upon as against the pharmacists. And I mean, I appreciate this plea came in for a different purpose in a different context, but at the moment I'm struggling because most of the particulars are about the manufacturers. Where do we get to the pharmacists?
I think it's subparagraph C. Deals with that particular issue.
But what's that got to do with pharmacists? All that's simply saying is 90% of prescriptions were written generically or more, and then it went down to 70% after the guidance. What's that got to do with it?
I think my lord is right about that. I'm being directed to subparagraph E.
Yeah, well, that's simply saying that, which is a statement of the obvious, that a pharmacist that gets a generic prescription can dispense generic product. That's both obvious and not in dispute. But again, what's that got to do with a claim of infringement by pharmacists?
Yes, I think my lord is right.
I mean, I've only read these particulars very quickly, so I may have missed it, but I can't see anything here which amounts to a plea either that the pharmacists were the people who prepared the composition, or that they did so for a particular patented purpose?
Yes.
I mean, if there is anything, show us, but
No,
I can't see it.
I don't see it, my lord. I think subparagraph U is the closest it gets because that addresses dispensing in itself. But I accept that's dispensing of the product obtained directly by means of the process.
That's a 1C. That's a 1C claim. And as you said right at the outset, what we're focusing on now is a 1B claim. You have to show an arguable case that pharmacists are using the process.
Yes. And basis, my lord, we pursue on that is what the Court of Appeal said.
Okay. Where do we find that?
I'm afraid that is.
Don't. I didn't think it was in the Bible. No.
That's quite right.
May I explain why I haven't read it?
I'll just hand that, please.
So is this the first judgment or the second
It's
one?
the second one.
Thank you.
Thank you very much.
And the section on infringement starts at page 59 of the report, paragraph 184. What I wish to take the Lords to was paragraph 212, which addressed my Lord Justice Arnold's application of the first Court of Appeal decision. You'll probably be aware there was an appeal from the application for interlocutory relief, interim relief, heard in 2015. This is the 2016 appeal from the trial judgment. And paragraphs 212, 217, the Court of Appeal deals with the approach of my Lord Justice Arnold. And at 217, they record that what my Lord was called upon to decide was whether Act Harvest knew or could foresee that some of the prescriptions written generically for pregabalin to treat pain would in fact be fulfilled with decay.
Well, can you enlighten us as to how that assists you? First of all, that is directed to infringement under section 61C, which you're not relying on. Secondly, it's applying a test of foreseeability, which was roundly rejected by all members of the Supreme Court.
Could I answer that by just moving on, my Lord, to 221? My Lord is absolutely right. It was roundly rejected by the test of the Supreme Court. But as I've said, that was an overture test. And
So you want to have another crack at persuading the Supreme Court for a foreseeability test? Is that what this comes to?
we say this would be an arguable case both on a foreseeability test and on the test set out by Lord Assumption as well, which I'm going to come to.
Okay.
Paragraph 221. This is under indirect infringement. We'll see the submissions of Mr. Miller for Pfizer, who submitted the process of the invention would be put into effect by the ascription of purpose by the pharmacist to generic pregabalin supplied by a manufacturer. Although one way this might be done by an express statement on a label applied by a pharmacist, is not the only way. And in paragraph 222, Mr. Speck for Octavis say accepted that the application by the pharmacist could be an act of manufacture. Now, I accept this.
But that's first of all, that was for the purposes of that argument only. And he said that manufacture was complete at the stage the product left the manufacturer. But in any event, that's a label ascribing the patented indication. Whereas your case, you've told us, or your primary case at any rate, is that there's infringement even if there's no statement of the patented indication. How on earth does that work?
Well, Mr. Miller's submission was that this could be an express statement on the label, but not the only way.
Yes, but you were relying upon what Mr. Spett was prepared to accept for the purposes of his argument.
These would be just questions of fact as to what is said on the label. And in due course, the evidence before the trial judge will be what is put on the label by pharmacists.
But what are you relying upon? What is your case?
I'm relying on both possibilities.
Well, I understand how you put the case if the indication is stated on the label. How do you put the case if the indication is not stated on the label?
We say that the particular box of pregabalin, by the placing of the dispensing label, in other words, its allocation to a particular patient for a particular use, amounts to a description of purpose for that pregabalin for that use.
But how does that work when no use is stated?
Because simply as a matter of fact, it would be used for that purpose. It's not so much that it needs to be said on the label that it is for whatever use it is, but that once that box, amongst the many thousands of boxes supplied by that manufacturer, is put in effectively, is dispensed, at that point it is for that patient for that use, because that patient has been prescribed that box for that use. And if my lords just go to the Supreme Court decision. It's at tab 5 of the authority. Page 255 is the same. And as I've said, infringement was overturned. Claims 1 and 3 have been held invalid. And there was a three-way split in the reasoning. Lord Sumption Reed said that the relevant test was one of outward presentation. Lord Mance said, I'm sorry, obviously, summarising.
Well, let's focus on Lord Sumption, because you said you were arguing either for foreseeability, which everybody rejected, or alternatively Lord Sumption's test. Now, how does your case work on Lord Sumption's test of outward presentation? I mean, I can understand how it works if the label says this is for inflammatory pain. But how does it work if the label doesn't state the indication? Because then there's no outward presentation.
Well, the test at paragraph 84, Lord Sumption, was that the badge of purpose is the physical characteristics of the product as it emerges from the relevant process, page 290, and including its formulation, dosage, packaging and labelling, and patient information leaflet. It's a matter of fact as to what Dr. Reddy's product in this case would say. It's not necessarily, we say, limited to what the product is actually authorised for. There may be statements in the patient information leaflet, for example.
But you've got to plead and prove this. I mean, and sorry, this is all. I'm just flabbergasted because you know what's in the skinny label. It's a matter of public record, so you don't need to speculate. And speculation is no basis for bringing a claim anyway. So if there's something in the skinny label that you're relying upon that you say amounts to suggesting that this be used for inflammatory pain, then you plead it.
Yes.
But, I mean, how does this work? I just don't begin to understand this work. I mean, leaving aside the fact that Lord Sumption is talking about how the thing emerges from the factory once it's been packaged up with the PIO, you've got to point to something that constitutes outward presentation of use for inflammatory pain. And at the moment, you seem to have nothing.
Well, my lord, we say that in the application of the test, it doesn't necessarily have to say on the label inflammatory pain. It's the label itself which amounts to the packaging and labeling patient information. But in some case, it may well do. And as we said, it's a matter of fact as to whether it will.
Well, as I say, I perfectly understand how you say that test is satisfied if you've got a label put on it saying this is for inflammatory pain. But I'm utterly baffled at the moment as to how you put the case if there's no statement of the indication.
I hear that. Lord, I accept that we haven't put the facts in the pleading, but these are just difficult issues, both in law and fact, that we say, my lord, don't lead to the conclusion that this cannot be argued. And in particular, for example, we've proceeded in discussion on the premise so far that pharmacists don't know what the indication is. But again, that's not necessarily always correct. I think the Lord said in trial judgment that pharmacists generally don't know. But in fact, there have been recent developments in, for example, summary care records being made available to pharmacists. And it cannot be said that pharmacists do not know what the patient is being given pregabalin for. In many cases, they do. So that on its face would engage the test under subjective intention potentially if the generic is dispensed, or indeed may also amount to an outward presentation where it's actually stated on the label, on the dispensing label itself.
All right, well, at the moment, we've been trying to understand your case. Have you told us everything you want to tell us as to the way that you put it?
I think I have, my lord. Let me just check whether. I think the final point is simply that, of course, we would be able to particularise further insofar as my lords recognise an arguable course of action. But that's something I think we're later.
Right, well, thank you very much, Mr. Austin, unless either of my lords wants to ask anything further. No, thank you very much. Right, is it Mr. Nicholson going next?
It is, my lord. My lord, subject to any points your lordships would like me to address immediately, I was planning to address the topics broadly in the order that we take them in the skeleton, and was in fact adopted by my learned friend, Mr. Bolton, yesterday. Namely, I want to highlight a few points on the background, specifically in respect to the overall Dr. Reddy's litigation, and the way that Dr. Reddy's inquiry claim is brought. I then intend to address Appeal Ground 3, infringement by the pharmacist under established provisions of the Patents Act, and then turn to Appeal Grounds 1 and 2, which we call infringement by nobody, where Warner-Lambert seeks to deduct Dr. Reddy's losses arising out of what we say would have been non-infringing lawful sales on the basis of an alleged monopoly for which we cannot find any support in established patent law. Now, for completeness, I was going to address your lordship as to the question of whether your lordship should decide the non-infringe monopoly point substantively on this appeal, but it's rather fallen away with my learned friend's change of position yesterday that now all three parties are inviting your lordships to deal with the factual issue. And I must say, just to preface it, that as to ground 2, I had reached the same logical conclusion as my Lord Justice Arnold, that ground 2 has got no teeth to it, now that it's conceded by my learned friends that this court is in a gooder position as to
decide the point today. We all invite you to do so, without needing to take into account developing law, novel points, potential facts that might come out of the woodwork. And my learned friend's rightful concession that this court should deal with it should have equally been made before the trial judge. It's right in this court. Nothing has changed. And the same point, therefore, can be taken in front of the trial judge. And there's nothing comes out of this ground two as some further reason why this court should interfere.
Well, the trial judge did decide it.
Right, exactly, my lord, exactly. On background, up until the 17th of May 2013, Warner-Lambert had two relevant patents, one for the pharmaceutical compound for pregabalin, and then a second one for the second medical use for pregabalin for the treatment of pain. The compound patent was subject to supplemental protection certificate, which could have allowed Warner-Lambert to extend its life to the 17th of May 2018. And for reasons which I suspect we will never know, Warner-Lambert chose to allow the supplemental protection certificate to expire on the 17th of May 2013, some 5 years earlier than they needed.
Well, you say chose. I mean, the evidence at trial was incomplete. They definitely allowed it to happen by failing to pay the renewal fees.
Yes.
There was some suggestion that that was done deliberately, but I was not in a position to make a conclusive finding to that effect, and it wouldn't have been relevant anyway.
My lord, there's further factual background to it, but I'm not.
It could have been done.
It could
accidentally.
It could have been extended. It wasn't renewed in multiple offices all at the same time around the world, which we say infers that there was some collective decision in it. But as it is, it wasn't renewed.
Yeah.
I mean, it doesn't matter, does it, for our purposes?
No, I don't think
why it wasn't. I mean, if they missed a trick, they missed a trick. If they had some good reason, well, so be it.
So be it. Now, Warner-Lambert still had data exclusivity, which prevented generic manufacturers obtaining marketing authorization until that expired on the 8th of July 2014. And the consequence of all of this history is that from the 14th of October 2013, it was apparent to any generic producer that they would be free to obtain a marketing authorization for so-called skinny label pregabalin with effect from the 8th of July 2014. And as my learned friend Mr. Austin explained briefly earlier, skinny label pregabalin is pregabalin which only has a marketing authorization for the off-patent indications, and in this particular case that's epilepsy and general anxiety disorder, or GAD. So after the 8th of July 14, a number of drug manufacturers came to market, and as it happens, Dr. Reddy's was the first generic on the market, obtaining a marketing authorization for skinny label pregabalin on the 12th of February 2015 and launching its skinny label Alzane on the following day. Now, another producer came to market in the early phase, and that was Actavis, and its skinny label was Lacant. And importantly, Warner-Lambert decided to sue both Actavis and Dr. Reddy's for infringement of at least claims 1 and 3 of the second medical use patent. The pleadings are nigh on identical, and both defendants counterclaimed for revocation of the whole of the second medical use patent, alleging the same to be invalid, and relief from Warner-Lambert having made groundless threats of patent infringement by writing letters which Warner-Lambert sent to various pharmacy groups about potential infringement of the second medical use patent by dispensing skinny label. Now, your lordships yesterday saw the list of recipients of threatening letters in the inquiry pleadings, and as my Lord Justice Arnold pointed out, letters were sent effectively to every pharmacist in the country by way of addressing them to the so-called superintendent pharmacists. Now, it's convenient to point out that Warner-Lambert has admitted in the inquiry that each such letter was an unjustified threat of the patent infringement. It wasn't only accepted that there was unjustified threats before Mr. Justice Burris as the liability phase closed. It's expressly pleaded in the inquiry pleadings in this action. And for your Lordship's reference, the assertion of unjustified threats is in Core 13, page 142, paragraph 30. And that's responded to by my learned friends in Core 14, paragraph 165. Page 165, paragraph 35. And there's a whole load of red amendments there where they tried to withdraw the admission, and that was refused by Mr. Justice Zacaroli. And the resultant pleading is in the supplemental bundle at 16, page 215, paragraph 35. They're asserted to be unjustified threats, and there's a clear and materially unrestricted acceptance. Does your Lordship want to look at those? Perhaps if I start at Core 13. (142) paragraph 30, we say, on the following date, Warner-Lambert made the following unjustified, actionable threats of proceedings for patent infringements against doctors and pharmacists in respect of prescribing and dispensing non-Lyrica pregabalin, including our product Alzane, and then the letters are listed out. And then if we go directly to the pleading as it now stands, which is in tab 16, supplemental bundle, tab 16.
So this is the pleading with those amendments which were allowed by
That's
Mr.
correct.
Zacaroli, but not with those which he refused. Is that right?
Exactly.
Okay, thank you.
And at paragraph 35, paragraph 30 is admitted, save for completeness, it was Pfizer and not Warner-Lambert who was held to have made the threats. Warner-Lambert does not contend that this affects whether it is liable for the threats. So we say there's a complete and materially uncaveated admission in respect to that. And as my learned junior reminds me, an attempt was made to withdraw that admission in front of Mr. Justice Zacaroli. That was refused and isn't appealed. Now, as it happens, another generic, a company called Mylan, had issued its own revocation claim against the whole of the second medical use patent as early as 24th of June 2014, before Actavis and Dr. Reddy's had launched their products and were subsequently sued. Now, for no doubt its own reasons, despite Dr. Reddy's being first to market and the pleas against Actavis and Dr. Reddy's going absolutely hand in hand, Warner-Lambert's main efforts, including seeking various forms of interim relief, were all focused primarily against Actavis rather than Dr. Reddy's. Not to say that we weren't delighted. But Warner-Lambert first sought an interim injunction against Actavis, which was refused. It then applied for the NHS guidance order against Actavis, and the substantive...
Well, you say against Actavis, the respondent to the application was NHS England.
Sorry, your Lordship is absolutely right, but it was in the Actavis proceedings. Sorry.
Yes.
Now, the substantive dispute as to the validity and infringement of the patent by so-called skinny label pregabalin products went all the way to the Supreme Court in proceedings between Warner-Lambert and Actavis, and on validity only, Mylan as well. Now, during that period, Dr. Reddy's remained on the litigation sidelines, but not without real and significant interest in the proceedings. It was still actively marketing its skinny label throughout the period, albeit in a market which had been disrupted by the threats and by the ongoing NHS guidance, and it secured a sizable part of the generic pregabalin market. It also closely monitored the proceedings, repeatedly sought inclusion as a beneficiary as various interim orders were made, including the guidance order and only extended the formal stay of the proceedings against it by consent with Warner-Lambert, piecemeal as the case proceeded from trial to trial and court to court. Indeed, as is apparent from the order of Mr. Justice Burse, despite the action being stayed, just the interim payment on account of costs was £185,000, and that's in Core 10 at page 167. And in fact, the total cost spent by Dr. Reddy's in the liability phase was some £484,000. And just to be absolutely clear, there was never any agreement that Warner-Lambert and Dr. Reddy's would be bound by the outcome of the Actavis and Myland litigation. It was simply that by mutual agreement, the Actavis and Myland litigation got to go first. Now, as the court will appreciate, the result of the first set of proceedings, following the Supreme Court decision, was that some of the claims of the second medical use patent were valid, at least as between Warner-Lambert, Actavis and Myland, and of course those are the inflammatory pain claims. However, none of the claims which have been actively pursued by Warner-Lambert for the purposes of infringement against Actavis were found to have been infringed by Actavis, simply by the act of putting skinny label pregabalin on the market, or for that matter, at all. Now, importantly here, it's potentially relevant that Warner-Lambert did allege that dealing in skinny label pregabalin infringed the inflammatory pain claims. Formally on the pleadings. It was well known that doctors were prescribing pregabalin off-label for inflammatory pain in reasonably significant quantities, as Mr. Justice Zacaroli noted in paragraph 59 of the judgment. And this had also been alleged in the Actavis proceedings, and in those proceedings, my Lord, Lord Justice Arnold, at first instance, recorded in paragraph 399 of the trial judgment, which your Lordships have authorities tab 2, that the evidence was that about 10% being prescribed for pain other than neuropathic pain. And as long ago as December 2016, and my learned friend Mr. Austin referred to this morning, in an application to vary the injunction against Sandoz, the judgment records at paragraph 29 that Warner-Lambert was then asserting that over 13.8% of prescriptions for pregabalin were being written for conditions covered by the inflammatory pain claims.
Well, yes, but just we're clear. Am I correct in recollecting that the question of infringement of the inflammatory pain claims was never raised in the activist proceedings? It was raised, however, at least to some extent, in the Sandoz proceedings.
My Lord, it's on the pleadings in the Actavis case, but it was never pursued. It was always, so the pleas were in the same form as the Dr. Reddy's, at least claims 1 and 3. And when it got to the point
that means nothing.
Exactly. And when it got to the point...
That's tantamount to a plea of 1 and 3 only.
Depending on the view of the court on the day. We've all had the at least be construed, at least in a broad sense, or at least in, you should say, what your claims are. I certainly accept, my Lord, that in
there was no specific plea in the activist pleadings of infringement of claims 2 and so on.
My Lord is absolutely right.
Whereas there was in the Sandoz proceeding.
There may have been in the Sandoz. I can't.
Well, it's set out in the judgment in Sandoz too.
Your Lordship, I'm sure, is absolutely right. I certainly accept that as the Actavis proceedings went forward, nobody was interested in the inflammatory pain claims. It was all about the neuropathic pain claims.
Now, this is all very interesting, but what's the significance of it for us? Is it simply that you say you are not bound by the findings about validity of the inflammatory pain claims, and therefore, if the amendment comes in, you will be entitled to challenge validity, or does it go wider than that?
My Lord, it goes to 2 issues. Firstly, it goes to the could and should have pleaded inflammatory pain claims against me in these proceedings. And secondly, that the issue of validity, isn't binding on me anyway. I wasn't involved in the proceedings.
Well, I think that's why you made the point. You didn't agree to be bound. That's what I picked up from it.
Exactly, my lord. Now, once the Supreme Court had finished, Dr. Reddy's waited 18 further months for the dust to settle to see what Warner-Lambert would do about its claim against Dr. Reddy's, which appeared, as far as we could see, bound to fail. Indeed, we took the view that it considered materially the same allegations of infringement by the supply of skinny label pregabalin as had been run all the way through to the Supreme Court, and there was no reason to think that the position ought to be any different as against Dr. Reddy's. And in the end, Warner-Lambert still having done nothing, it was my clients who brought the claim and the counterclaim back before the court for closure, coming before Mr. Justice Burse on the 16th of March 2020, some 5 years after the proceedings started, asking for a final order in the liability phase.
So just to go back to your previous answer, when you said it goes to two issues, your first one was it goes to could and should have pleaded inflammatory pain claims against you, i.e. Dr. Reddy's, whereas the appellant's point, as I understand it, or at least an important part of their case, is that that's not the case they're now seeking to run. They're seeking to run a case of infringement by the pharmacists, not by you. And they say that makes all the difference, and that's something you'll need to deal with.
I'm going to show your lordship that that's factually wrong, and my point will become clear as I just develop this through.
Very good.
Now, when we came before Mr. Justice Burse, Warner-Lambert were on full notice of the hearing. It was not something that went through on the nod or quickly. There was some 2 months between the service of the application notice on the 24th of January 2020, and indeed the terms have been debated in correspondence between the parties in the 2 months coming up to the hearing. Now, the order itself is at supplemental tab 10, and your lordships have seen it several times now. But the whole of the claim against the first defendant for infringement was dismissed. That's paragraph 1. On the basis that the claims are invalid, and of course they're the non-IPC claims, simple application of the outcome of the Supreme Court's decision. And then moving on to paragraph 2, we get the orders for the inquiry on the cross-undertaking and as a result of unjustifiable threats. And then finally, for present purposes, paragraph 6, Mr. Justice Burse made a declaration that Warner-Lambert has made unjustifiable threats of proceedings of patent infringement. And just pausing there, my Lord Justice Arnold asked yesterday about which parts of this order were really by consent and which were not. And overnight we've checked the transcript. Going into the hearing, paragraphs 1 to 5 were all agreed. And the declaration of unjustifiable threats was also made expressly by consent. But for some reason, it got missed in the drafting of the order, possibly because the parties felt uncomfortable with presenting an order to the court asking for a declaration by consent. And the transcript on page 42, line 21, Mr. Justice Burse said, "Okay, the one I will make is the one your opponents are agreeing to, because I will do it by consent, that the claimant has made unjustified threats for proceedings on a patent infringement. I am satisfied that by consent I can make a declaration of that kind, and I will." And that became paragraph 6 of the order. So although the face of the order doesn't show that it was by the consent, it was clearly the way in which Mr. Justice Burse approached it. Now, going back to the order itself, the part of the counterclaim covering the invalidity of the unpursued IPC claims was not separately dismissed, but it didn't need to be because those claims no longer mattered. There was no suggestion that there was any infringement by them following mutatis mutandis, the way in which things had proceeded against Octavius. And this order brought the liability phase of the action to an end, which is precisely why one sees at paragraph 5, by consent, that Dr. Reddy's was awarded all of its costs of the liability phase. All that remained was the inquiries to damages for which further directions are given at paragraphs 7 to 15. Now, obviously, and without doubt, had Warner-Lambert wished to say that Dr. Reddy's was wrong and that there were issues of liability that remained outstanding, that would undoubtedly have been the time to say so. Warner-Lambert could easily have said, but wait, I still have my inflammatory pain claims, and I wish to expressly allege infringement of those claims in the proceedings against Dr. Reddy. So the core infringement action on the remaining IPC claims still needs to be heard. They obviously could have done so. And in exactly the same way, had Warner-Lambert wanted to say that the pharmacist dispensing or otherwise dealing with skinny label pregabalin involved an infringement of the IPC claims, or that the pharmacist had done so, or they would have been infringing the inflammatory pain claims, so that all leading up to, so that the threats of patent infringement were in fact justified, then again, Warner-Lambert obviously could have done so. And thereby, as my Lord Justice Arnold noted yesterday, that would have formed a complete defence to the unjustifiable threats claim.
Well, is that right? I mean, it's one thing to say I've still got a claim for infringement against this defendant. It's something rather different to say, oh, by the way, I've also got a claim for infringement against somebody who has never been part of these proceedings.
So, on my counterclaim for unjustified threats, I take the role of a person aggrieved by threats. Usually they're not made to me. They're usually made to my customers, as in this case the pharmacists. And the statutory cause of action allows me to come before the court and say, these chaps are threatening my customers that they are going to be sued for patent infringement. And I am suffering loss because of that, because those threats are groundless.
That was exactly the reasoning in the trial judgment. So when you look at the relevant parts of the trial judgment, what you see is that taking the letters to the superintending pharmacist by way of example, they are construed as being threats to the pharmacists, and then it is held that activists is aggrieved thereby, so as to have a cause of action.
Exactly, my lord, I'm grateful. And the answer to that is your customers are infringing. I'm allowed to write letters to people who are infringing. So the statutory defence is to show that the pharmacists are infringing. But instead of taking that defence, instead of pursuing it to trial, my learned friends allowed the claim for unjustified threats to be entered in my client's favour.
Was it pleaded? You plead a counterclaim saying, I'm a person aggrieved by these threats against the pharmacists.
I pleaded a counterclaim, yes.
I'm just looking at section 72A, which provides a statutory defence to the patentee, saying, but it would have been an infringement.
Quite.
By the pharmacists.
Yes.
That's a defence to your claim for damages.
Yes.
So it doesn't require bringing the pharmacists into the action.
No, they almost never come into the action.
Yes.
Yeah.
Your case on the Henderson abuse, the could and should have. You're not saying they should have sued the pharmacists in this action. What you're saying is they could have alleged the pharmacists were infringing as a defence to your threats claim.
Your lordship is absolutely right. I was coming
so my question is, you plead a counterclaim. Did they ever get to a stage of pleading a defence to a counterclaim? Did they ever allege this would have been an infringement?
I believe that at the stage they denied the unjustified threats, but I don't have the particulars in front of me as to how fully they denied the threats.
Well, denying the threat would be to say I didn't write the letter. What you mean is they accepted they wrote the letter.
Well, not necessarily, because the argument that was run at trial was obviously they couldn't deny that the letters had been sent. The argument of trial was that on their true interpretation, they weren't threats of infringement proceedings against the pharmacists. But I did not accept that.
So they've got three potential defences. I didn't write the letter. I did write the letter, but it wasn't a threat. Or It was a perfectly justified threat because it would have been an infringement.
Right.
And the question is, if they pleaded that third one, then by consenting to paragraph 6, they've abandoned that contention. That's your submission.
Well, I go further than that because we're in the realm of Henderson and Henderson, and I'm looking at could and should.
You say whether they did or not, they certainly could have done.
Exactly. Absolutely could have done. Yeah. But instead, no, they have got no defence, was their position, to these threats being unjustified or groundless, which was my case, and they accepted it by consent. And as my Lord Justice Nugee points out, sorry, that's my train of thought. Yeah, so that's that's the position that we're in. That they could and should have pleaded it, and instead they consented to it. What we ended up with is that both sides and the court accepted that the liability phase on infringement, on unjustified threats, and on validity was over. Neither side had anything more that they wanted to add on liability over the outcome of the Actavis litigation. And a final
So you say that looking at Mr. Justice Burse's order, if the appellants were allowed to bring in this plea now, that would be flat contrary to paragraph 2b.
Absolutely.
Well, to the combination of paragraph 6 and
2B and
paragraph
6.
2b.
And it's also exactly what my learned friends attempted to do before Mr. Justice Zacaroli. One of the points that they don't appeal is that they wanted to withdraw the admission I showed your lordships earlier that these were unjustified threats and replace it instead with an allegation that the pharmacists were infringing and therefore the threats were justified. And Mr. Justice Zacaroli said quite rightly that's a direct attack on Mr. Justice Burse's order, on the judgment for threats that have been entered, and you can't do it.
Where does he do that?
I think it's paragraph 16 of the judgment, the call bundle. Yes, so paragraph 16 rejected the contention that it doesn't, that
Yes.
15 and then so on.
So then, if you're right so far, is the question whether there is any distinction to be drawn between the undertaking, the inquiry envisaged by paragraph 2a of Mr. Justice Burse's order and the inquiry envisaged by paragraph 2b, a point that we touched on yesterday.
Yes, and
But is that the question, or is that a mistake?
it's certainly a fact that I will address as I go through. That at the moment, although my learned friend makes much complaint about us rolling the threats and the guidance order and the effect of them in together, we very much agree with my Lord Justice Nugee's point, which is how on earth are you ever going to separate them? The guidance order was sent to the pharmacists, as were the threats letters. There's 14 days between the letter to the superintendent pharmacists and the sending of the guidance order to the pharmacists as well. Both of which, I'll show you the detail in a moment, but both of which say, be very careful with prescribing pregabalin if it's to do with pain. Warner-Lambert has got patent rights. You need to make sure that you are dispensing Lyrica when pain occurs. Now, the prospect of any court being able to determine whether there is a difference between the effect that the guidance order had upon pharmacists and the effect that the threats letter had upon pharmacists, we say is effectively fanciful. No doubt there will be some pharmacists who were more engaged by the guidance order. There will be other pharmacists who were engaged more by the threats letter. And there will be some pharmacists, potentially, who were equally engaged by both. Now, insofar as I put my inquiry claim, the result was more lyrica went out the door and less generic pregabalin. It makes no difference to me which was the causal motivation. It's only when my learned friends come along, and it really comes to a head only in front of this court and not below. It's only when my learned friend comes along and says, I want to apply the haircut, as he calls it, to losses following from the guidance order, but not losses flowing from the threats. And he's forced into that position because he hasn't appealed the ability to reopen threats. Suddenly it becomes front and central in the inquiry due to come in October. You've got to trace through or find some other way of allocating the causal reason for the change in the market to one order or the other. And we say that substantially changes the nature of the action. And it was already apparent from my learned friend's oral submissions yesterday that he's already positioning himself to say it really all stems from the guidance order and the threats added nothing. So we're not going to go in agreeing it's 50-50 or some easy mathematical split. He's going to be holding out at each and every step, but the threats did nothing. It was all about the guidance order, and he's entitled to his full 13.8% or whatever figure that goes up to when we come to trial.
So your understanding of what is proposed by the appellants, who accept that there could not be a patent infringement trial before the inquiry, would be that there would be a complicated causation exercise which would have to be undertaken if the amendment was allowed
In the October trial.
in the October trial,
Yeah.
to distinguish between the effect of the threats and the effect of the guidance, which might, if you succeed in the infringement trial, in resisting infringement or perhaps in having the inflammatory pain claims declared invalid, turn out to have been a complete waste of time.
Absolutely.
Can I ask a more fundamental question?
Yes, my lord.
If the infringement by pharmacists point was pleaded as a defence under Section 72A,
Yes.
I am effectively consenting to paragraph 6 that the inquiry defendants have abandoned that contention. They haven't taken it forward to trial. They've just consented effectively to judgment.
It potentially becomes some form of issue.
I was going to say, why is it not a cause of action estoppel or an
Cause of action
or an issue estoppel?
Um,
And I'm just looking at the way, because we were very helpfully handed Virgin this morning, the way in which Lord Sumption put it, paragraph 22, where he sets out what cause of action estoppel and issue estoppel stop, and they stop points that you've taken in litigation, which you either lose or which you don't take forward to judgment, and it includes points you could have run as a defence to a particular cause of action, but didn't run as a defence to a cause of action if they could have been raised.
my lord, I have great sympathy for that view. Part of the difficulty that we have with this plea, and it was well illustrated by the interchange with the court and my learned friend Mr. Austin this morning, is that what my learned friends are actually saying and what they intend to say is like picking up jelly with a fork. And we were before Mr. Justice Zacaroli with the skinny pleading, if I can put it that way, where my learned friends had a very free hand to say what they intended to do going forward. Now, it is possible that the amendments could have been objected to on the basis that they lacked particularity, they lacked clarity. But the result at interim hearings that are already scheduled for multiple days, and the judge is trying to decide issues and push off issues where they can be dealt with, is that we were at real risk of the plea in principle being allowed in, with particulars to be sorted out in due course. And because of the significance of this point, we want to nip it in the bud, and therefore we've taken the abuse of process, the Henderson and Henderson, the case management issues, which apply irrespective.
But how
of the
can one
precise
determine
form of
those
the claim.
issues without understanding the nature of the case? You can't understand the nature of the case without having the particulars. The whole thing is backwards, isn't it? You've got to start with a proper plea which sets out what the case is that they wish to advance, and then you can see how it interacts with the other elements of the case. I mean, you also get to see whether it has real prospects of success.
You do, my lord, and in an ideal world, that's where one is. The position that we take as to raising any issue in any way on the inflammatory pain claims is that it's Henderson has stopped, it's an abusive process, it's too late in the proceedings, run however my learned friend puts it.
Well, to be sure, but to be clear, is it your submission that we should, whether or not we get to that point, we should also consider whether the claim that they're seeking to advance is properly particularised and whether it has a real prospect of success?
My lord, I've thought long and hard on this question. I find myself in a position where that isn't something I invited the judge below to do.
To be sure, but we've just had an application by Mr. Bolton to amend his grounds of appeal. You can apply to amend your respondent's notice.
Yeah. My lord, you have had the application to amend, but I think probably more importantly, you've also had a oral explanation as to actually what the claim is and where it's going. And I think your lordships are in far better a position to take into account the merits of the claim as it's been explained by my learned friends than we could possibly have expected to be in front of the judge who was trying to deal with the issues that were on the papers in front of him, rather than ones that have been explored with counsel, having had a chance to think about them overnight.
Well, I think the formal position is that there is no respondent's notice.
Your lordship is right.
And it's up to you whether you make an application to run a point. If you do, we'll consider it and see what Mr. Bolton or Mr. Austin has to say. But going back to my Lord Justice Nugee's question, I think we ought to be told, please, as a matter of fact, was there a plea by way of defence to the threats claim that the threats were justified because there was an infringement of the inflammatory pain claims? I would imagine that would be a yes or no on which the parties would simply be able to tell us the answer. I have inferred that the answer was no, because I'd have thought we'd have been told about it if there had been, but perhaps that could be checked, and then we can be told by agreement between the parties one way or the other.
My lord, we will check the pleadings and I'll come back on that. Also on whether or not I wish to amend my grounds of appeal.
Your respondent's notice.
Respondent's notice. Perhaps I can take instructions over the short adjournment and confirm one way or another. There was a further point that I wish to make that arose from some discussions that were had yesterday in respect of section 60, subsection 2. What was formerly on the pleadings in my action was that Dr. Reddy's has infringed the patent pursuant to section 60, subsection 2 by supplying means relating to an essential element of the invention to pharmacists, with it being obvious or known that the pharmacist would put the invention into effect. Now, the only way that plea works is if my learned friends establish that the pharmacists were infringing the patent. And as previously, it was put on the basis of all of the claims, although in the Actavis proceedings there was a focus down to the neuropathic pain claims. The formal pleadings are at least claims 1 and 3 and are unlimited. But again, we say, had we have got, and that 60 sub 2 case was dismissed as well, And had we have got to the hearing before Mr. Justice Birse, and my learned friend's position being, actually, I've still got my inflammatory pain claims. I've had 18 months to think about it. I've had 2 months after Dr. Reddy's said it wanted the action closed and judgment entered in its favour. I want to say the pharmacist infringed the inflammatory pain claims in the proceedings against Dr. Reddy's in order to pursue my 60 subsection 2. Then my learned friends again could and should have said that. They didn't.
But on the basis on which the claims of infringement against you were in fact by consent dismissed was simply that they were premised on claims 1 and 3 being valid, and claims 1 and 3 were accepted to be invalid.
Your Lordship is absolutely right, but the liability phase closed. On the pleadings, they were broader. They couldn't. There was no action to continue on infringement of the inflammatory pain claims. There was no suggestion that there would be another trial to deal with those issues. They had the wide ambit of their allegations of infringement.
So they could have widened, but they would have had to amend their Section 62 claim against you on the basis that the inflammatory pain claims in 257, 8 and 9 were still valid, and that by supplying the generic pregabalin to the pharmacists, you were infringing Section 62 because the pharmacists would have been infringing Section 61B when they
Absolutely, they had
dispensed it.
They had the generic plea that we were infringing under 60 subsection 2, relying on the supply of our product to the pharmacists who would have infringed. And they knew they only had their inflammatory pain claims left. If we'd have turned up in front of Mr. Justice Birse and said, all of this is done, all of this is over, if they'd have said, regardless of either interpretation as the pleading as it stood, or we need to amend this action that's been stayed for the last 4 years in order to take into account the result of the Supreme Court, and we want to specifically allege all or any combination of the above on threats on 60 subsection 2, but all on the basis that I'm now focused on the inflammatory pain claims, which everyone knows this pregabalin is ultimately being used for in reasonably significant quantities, then it's unthinkable that Mr. Justice Birse would have said, you're shut out, you can't do that amendment. And my application to close the liability phase and move on to the inquiry would have failed. And instead, we would have had a patent infringement and validity action focused on the inflammatory pain claims. No doubt if my learned friends in the processes, my learned friend Mr. Austin was explaining this morning, wanted to move on to 61B instead of 61C, that would have been put into account, and all of this would have been in proceedings between Dr. Reddy's and Warner-Lambert. You wouldn't have added, I mean, they could have tried to, but they wouldn't have needed to add the pharmacist because they hadn't to that date. And there was no particular point in adding the pharmacists. It could have run infringement of this patent and validity in defence of it as against Dr. Reddy's on the very issue that my learned friends are now seeking to bring into the inquiry. So when one asks the question, could or should, absolutely could, absolutely. And should they have done it, they knew all of the facts as the trial judge in this action went through as to the supplies, as to what the outcome of the Supreme Court was. It all could have been dealt with. Now, there were a couple of points, I've started getting into ground 3, but there were a couple of points on the inquiry claim I just want to make sure that I have covered. I think I have actually, I've gone through it. Yes, I was just going to show you that the guidance order went out to the pharmacists. Perhaps we could pick that up in the supplemental bundle, tab 7. On the second page of the order, which is page 151, the order at paragraph 1 is the respondent which is the National Health Service, has until 4 p.m. on the 3rd of March to take all necessary steps to ensure that the guidance in Schedule 1 is published to at least the third parties in Schedule 2. And if we go to... Do your Lordships have that in paragraph 1? If you then turn forward to page 155, we have Schedule 2, and the point for me to pick up at this point is the NHS Business Services Authority. And if we then turn back to 153, the form of the guidance, to the NHS Business Services Authority, the following notice should be distributed to all community pharmacies on or before Friday the 6th of March 2015. So this was going out via the Business Services Authority, the NHS and Business Services Authority, to all community pharmacies. And then the letter that's below, on the third line, we pick up treatment of pain. So we're not just talking neuropathic pain, we're talking pain. And as part of that dispute, the court has required NHS to issue this guidance. Our guidance is that because of Warner-Lambert's patent rights, and then we can scroll forward to paragraph 4, when dispensing pregabalin, if you've been told that the treatment is for pain, you should ensure, as far as reasonably possible, only Lyrica, the branded form of pregabalin, is dispensed. Otherwise, you're not restricted. And we say, without doubt, this letter is very much of the same ilk of a threats letter if it were written without sanction of the court. And as I was making the point earlier, we can see no logical distinction between letters that were sent out on Friday the 6th of March or a few days later pursuant to this order, and for example the threats letter sent to the superintendent pharmacists on the 20th of February. They're only 14 days apart.
Well, the first one was even earlier, was the 10th of December.
Quite, my lord, yeah.
So actually the threats come first, by and large, and the guidance comes second.
With very much the view that insofar as people were motivated by the letters, which certainly Warner-Lambert expected them to be, the threats are probably more important than the guidance order. But either way, we're in a scenario that trying to untangle between December, the earliest letter, 10th of December, and the 20th of February, I think is the last day, is a very, very short period of time where a series of letters were being sent and the guidance order. And your Lordships may have picked up that my learned friend's desire on his pleading and his contention for the forthcoming trial is not only do I need to do threats on one hand and guidance on the other, he wants threats from letter 1, threats from letter 2, threats from letter 3, all the way through to 6, then the guidance order. I mean, it's just turning the inquiry where we know the amount of pregabalin being dispensed generically slumped over this period where the guidance was given. You start making a distinction in the damages available, it causes a massive problem for the inquiry and puts up the amount of work that the trial judge and all the parties have to do considerably. And as my Lord Justice Mayall's points out, it may all be toward, because my learned friend accepts that the actual finding on the inflammatory pain claims isn't going to come until considerably after the inquiry has itself taken place. And my learned friends certainly don't suggest that a 25-day fixture in October that everyone's getting ready for should be taken out of the list in order to allow this to be dealt with before we get.
If it's just a question of the slump in the amount of generic pregabalin that's prescribed, why is it going to take 25 days to try?
Because on each and every point, my learned friend has a lot he wants to say. Our position all the way through, Dr. Reddy's position, is we've pleaded an incredibly simple claim.
On your case, you don't need to distinguish what the cause is.
We've always said, and we've made repeated applications to the court, that Dr. Reddy's inquiry claim is simple, straightforward, and needs 5 to 10 days or tops in court. I think we've often said 5 or 6 days.
So you'll close your case in a day or two and see what Pfizer has to say.
Well, quite. What's happened is we were firstly had all the other parties come in, so we were up to in the 30s number of claimants represented in 9 separate claimant groups. We've been dragged into multi-part common assumptions trial, then a common interest trial, then a separate series of quantum trials. And at each stage, we've tried to deal with these saying, you don't need to look at everyone at the same time, because if you do, what happens if a party settles? We never get to know what their position in the market was. Now, in fact, as Dr. Reddy has always said would happen, everyone except myself and my learned friend have disappeared. We don't know anything about the terms upon which they've settled. We don't know what the assumptions are as to any of that. We've been dragged through 2 or 3 years of litigation, just pushing up the complexity, delaying to 8 years the time in which we will get compensation for losses that happened 8 years ago. We're now going to 25 days in October, and that's because Mr. Justice Zacaroli acceded to my application that with the narrowing of the parties and the narrowing of the issues and the outcome of the counterfactual assumptions trial, that we should all have an equal counterfactual, so not different sets of facts. We didn't need to have another 2 trials, we could do it all in one. And I think my learned friends wanted to put the duration of that up from 20 days to 25. And that's where we've ended up. But our position has been all the way through that the Dr. Reddy's inquiry couldn't be simpler. It's going in, looking at the 2 changes in the market and doing some maths and multiplication through. And all the way through this procedure, we are being hit repeatedly by long, elongated pleadings that you can't understand what's really being said, that are explained in court orally, where suddenly there's a point forward. And now we want to add a infringement and validity case, which pretty much common ground that unless it's thrown out as being wholly unarguable, it's destined to go on infringement all the way up to the Supreme Court. Because my learned friends rightly say all of the arguments are obiter, and it's desirous to take it along that path, delaying the matter for years and putting up costs. And one can quite see in those circumstances why Mr. Justice Zacaroli looked at the case management issues and the prejudice to my client and said, this isn't what Dr. Reddy's thought they were getting into when they had the order sealed by Mr. Justice Burse and pleaded very short and very simple points of claim. And that was part of his reasoning for rejecting this, even if he's wrong as to Henderson and Henderson, even if he's wrong as to abuse of process. And we say he's absolutely right for the reasons he gave.
You'll have us all in tears in a minute.
I'm sorry. Your Lordship provided me with an opportunity to tell you what I really thought, but I'm grateful. Yeah. So, I think I've covered a vast amount of what I actually want to say. The judge dealt with it in 3 ways. Actually, there's a precursor to this that I need to draw your Lordship's attention to. As we approached the hearing before Mr. Justice Zacaroli, my learned friends were putting its intended amendments, and your Lordships have seen hints that there was attempts to play with the threats claim and elsewhere. They were saying that they wanted to plead infringement by Dr. Reddy's as well as infringement by the pharmacist. So much so that when my skeleton went in, it dealt with the abuse in infringement against Dr. Reddy's. That actually, I think, is the primary Henderson abuse line, with the pharmacist following. By the time we got to the hearing, my learned friends produced new draft amended particulars of play, where they sought to excise the allegations that Dr. Reddy's was infringing. And in those circumstances, it's not really surprising the poor judge dealing with a multi-day CMC and then subsequently reserve judgment ended up dealing with writing in much of the relevant paragraph of about the effect of alleging infringement against Dr. Reddy's rather than alleging infringement by the pharmacists in the Dr. Reddy's claim. Now, at the hearing before Mr. Justice Zacaroli, the distinction that's now taken in front of this court wasn't anywhere near as precise as my learned friends made. But in fact, as I've already discussed with my Lord Justice Nugee, the attempt to say that this is somehow different because it's effectively an estoppel against pharmacists, and I'm not a privy to a claim being brought against the pharmacist. It's all entire smoke and mirrors. My learned friend's amendment doesn't seek to add the pharmacist as a party. He's raising the issue as to infringement by the pharmacist, as between Warner-Lambert and Dr. Reddy, just as he was in the original liability claim, 60 sub 2 on the defence to unjustified threats. And we say that when you look at the relevant paragraphs of the judgment, which are in the sort of 50 to 60 area where this is being dealt with, and you stand back and you look at the reasoning that the judge has given, it applies equally to infringement in the Dr. Reddy's claim by the pharmacist as it applies to infringement by Dr. Reddy's itself. And there's three grounds. There's the Henderson and Henderson, there's the abuse of process separate from Henderson and Henderson, and then there's the case management reasons. And indeed,
Sorry, the second of those, as I understand it, is the collateral attack on the order of the 16th of March. Is that right?
It certainly includes that, but the judge, it's in 63, 64 and 66 to 67. He took in elements of prejudice in that head, such as Warner-Lambert's contention. My learned friend's been a bit subtle about it in front of this court, but I was hearing what he was saying because he said the same before the trial judge. He says he's not stopped for alleging infringement of the inflammatory pain claims, but I am stopped from having another go at the validity of the patent because the same order, that of Mr. Justice Burse, somehow or another works as an estoppel against me on validity, but not against him on infringement. And that was a factor which Mr. Justice Zacaroli took into the wider consideration of abuse, as on the assumption that my learned friends are right, that was a prejudice that I'm suffering from the way in which this has come about. But principally, your lordship is right. It's the collateral attack. And my Lord Justice Arnold raised yesterday the question of exactly what I'm saying on my respondent's notice. Would it have been a collateral attack on the judgment? I say yes. Or because Warner-Lambert were not allowed to run this as a late defence to threats and have not appealed that decision. So therefore, this is an attempt to circumvent the refusal of the other proposed amendment. And I say yes to that too. Obviously, the second limb of which I couldn't run at first instance was both attempts to amend were on the table. So it's a matter that arises only on this appeal. Now, coming into the Henderson and Henderson framework and just saying quickly what I've already said, but putting the right words around it, it was Dr. Reddy's who was vexed with the assertion that pharmacists were infringing in the first action. It won that. It won the threats argument, it won the 60 sub 2 argument. In the current case, if the points are allowed to come back in, then it is Dr. Reddy's and no other who is going to say for the court, who is going to be vexed with the same issues being arising again. All my learned friends have done is, in the last 3.5 years or so, 2 years or 2.5 years since the order of Mr. Justice Bears, is they've thought long and hard about their IPC claims. They've thought that they might be able to get this to run under 61B instead of 61C, and a slightly different way of putting the 62 case, as we heard for the first time when your lordships heard it, and they want to have another go at this. There's absolutely no reason, if my learned friends are right, on a Henderson basis, that whenever, assume a party has got a patent, he alleges infringement, he applies for an interim injunction that takes the defendant completely out of the market, takes the case to trial, and he fails on infringement. There was something wrong with knowledge or something wrong with the claim construction, the product doesn't infringe. So you then proceed to the inquiry on the cross-undertaking. And my learned friend says at that stage, well, I'm now considering a case that was put in a slightly different way. I'm now considering hypothetical acts which never in fact happened. And I can run my infringement case in a better way, in a new way, the second time around on the inquiry, and say, in fact, you were infringing, and in fact, therefore, I pay you no compensation on the cross-undertaking. We say it's exactly the type of scenario that Henderson & Henderson is designed to stop, bring finality to the litigation, to stop the defendant being vexed twice, or the claimant having two bites of the cherry, the two sides of the same coin there. And my learned friends are trying to go straight down and through that line.
So it's implicit in what you've just said that you admit that it makes no difference that one's concerned here with the counterfactual rather than the actual world.
Yeah, your lordship is absolutely right. What I would say on that is, look, your lordship sought to investigate with my learned friends yesterday the fundamental problem that there is no difference in the nature of the acts of the pharmacist which did occur in the actual, and those that form the basis of the allegations of infringement in the alleged counterfactual. Your lordship asked my learned friend in terms what the difference was, and he was unable to identify anything. Stepping back from these proceedings, generally speaking, the liability phase of a patent action almost never considers each and every instance of infringement. What matters at the liability phase is that each type of infringing act is considered. The counting of how many times each occurred, be it whether it's in the damages inquiry or on the cross-undertaking or threats, is left for later. We also say that in a normal patent action, there's always retrospective and prospective allegations of infringement. The standard plea is on such a date, the defendant disposed of type 2 widgets and thereby infringed the patent. And unless restrained by this honourable court, the defendant threatens and intends to dispose of a lot more type 2 widgets. And we respectfully say to my learned friend, it's a nonsense to say that an action can be brought on the historic disposals, but never in respect of prospective points. And in fact, in the present case, Warner-Lambert were at all times sharply focused on the perspective, the what would happen if the pharmacist were hypothetically to dispense Dr. Reddy's pregabalin. The whole purpose of the threatening communications and the NHS guidance was to stop acts that hadn't yet happened from happening. The particulars of claims sought prospective injunctive relief as well as retrospective damages. And in fact, that was the relief that was granted. Together with threats, the NHS guidance did stop some of the hypothetical acts from happening. And as a consequence of the cross-undertaking, we're now here in a world where none of the acts, where we assume that none of the acts that were in fact stopped from happening were stopped, and therefore work out the compensation. So the allegedly hypothetical acts were the very subject of Warner-Lambert's allegations that it was making when it was obtaining the relevant orders. And those allegations are no different in substance to the allegations which it now seeks to raise on the inquiry. And it puts it in terms: dispensing of pregabalin products supplied by Dr. Reddy's would have infringed the inflammatory pain claims. So we say, nice try, but attempting to draw a distinction between the acts which actually happened and those which were prevented, and the same prevented acts in the so-called counterfactual, is just simply an attempt to bypass Henderson and Henderson and makes no logical sense whatsoever. Moving on to, actually I'm going to deal with illegality on Henderson and Henderson first, because as I understand it, my learned friend is only saying illegality on Henderson. My learned friend seeks, in his skeleton, he seeks to combine Henderson and abusive process, but we say it only seems to make sense when you actually look at what he says on the Henderson basis. And what this really comes down to is Henderson and Henderson abusive process is a public policy issue, and the authorities that my learned friend raises consider, we say obiter, or hypothetically, that is there a time that comes where other issues of public policy, such as those of illegality, have to be balanced against the public policy underlying Henderson and Henderson vexation finality. And there may be times where some other public policy trumps the rule in Henderson and Henderson. We don't disagree with that approach as to the law at all. And just to be clear here, we point out that this isn't actually a point that we understood was being run below. Below the point that was being taken was more one of ex turpi causa, that Dr. Reddy's, even if pharmacists or Dr. Reddy's were infringing the patent, if they were infringing the patent, could they benefit from their own wrongdoing in claiming losses from Warner-Lambert? And that's where I draw a distinction, and why I haven't cited Servier and Patel and the like, because it's really the ex turpi causa point that those authorities are dealing with. And the point that my learned friend is seeking to run on this appeal doesn't get to that stage, doesn't get to the accounting deduction at this stage. I'm assuming he can have an argument on deduction when we get there for the purpose of this application. But what my learned friend is saying is, assume I am Henderson and Henderson, as the learned judge found below. My answer to that is that Henderson and Henderson doesn't run where there's illegality. And I say, the plea that I want to run, says my learned friend, is that you're infringing my patent. That's wrong, that's illegal, that's illegality, and I don't need to worry about Henderson and Henderson. And what we say as to this is, when you look at the authorities my learned friend has cited, although they hypothetically talk about this balancing act, and we don't disagree with that in principle, none of the authorities he puts forward is good for the proposition that a mere civil wrong, a mere tort, such as patent infringement, is good enough to trump the public policy in avoiding, in finality of proceedings, the public policy underlying Henderson and Henderson.
It's not suggested to be a criminal offence.
Well, absolutely. It's not. It doesn't run as a criminal offence. It's a mere tort. And he complains that...
Sorry to interrupt you, but let me see if I've understood that point correctly. So, do I understand the point you're making there is that if a mere civil tort was enough, you could never have a Henderson objection where the allegation was a civil tort?
Your Lordship is absolutely right. And focusing our attention more, I say in a patent case, you can keep suing for infringement. As long as you come back with a slightly different variation of it, you're never going to be Henderson. It goes back to the example I was giving on what happens when you have a full interim injunction, you stop the defendant, you go on the cross-undertaking, you can run another infringement case because Henderson never applies. And it's a bold proposition for my learned friend to come forward and say a civil wrong is enough. And it's him who is devoid of any authority for that proposition. When being asked about it by my learned friend, my Lord Justice Arnold, yesterday, the best that my learned friend could manage was Spencer Bauer says subversion or illegality. Well, subversion must be something slightly less than illegality. And what he didn't do is direct your lordship's attention to the examples of subversion given by Spencer Bauer in 7.1 of the authorities bundle. Sorry, paragraph 7.1 of Spencer Bauer. It's in the authorities bundle, tab 20, page 690. And you look at that.
Well, those were to do, as I recall, with subverting an order of the court.
Well, exactly. That's included within them. So, sorry, just turn it up. It's tab 20. It's paragraph 7.1, and we say the 4 specific examples given are: firstly, would deprive B of a right protected by public policy, that it would prevent B from performing a public duty, that it would give B a power which the law denies him, or that it would give the court a jurisdiction it lacks. And we say none of these engage the tort of infringement of a patent or anything like it. Nothing to do with public policy here. In many ways, patent infringement is very much a private matter, or a matter of private interest, notwithstanding that it's founded on your lordship rightly pointed out, they aren't strictly let as patent anymore, but it is a grant by the state against the world. But the infringement issue is a matter of private law and a mere civil tort. Now, my learned friends have said nothing in writing, certainly not below, or in oral submissions, to suggest any reason to think that this goes further. And in the wings, insofar as one wants to get into Servier and Patel and the like, what one does see is when it comes to the discounting, there's been a wrong, and can I now make a discount from it? The Supreme Court was clearly of a mind that you needed criminal or quasi-criminal act to do the discount. Now we're looking earlier, well, what on earth is the point in allowing him to run a point on something less than a quasi-criminal alleged wrong, bypassing Henderson and Henderson, to then end up at a stage where when he comes to do the deduction, I say at that stage, well, the rule in Servier means you can't deduct it anyway. But what I'm really focusing on is what my learned friend is advancing. It's an important exception to the rule. It's a surprising contention, we say, and we can go no further in answering it than to say he hasn't made the proposition good on the authorities he's put before the court. So, my lords, I think in the process of going through that somewhat out of order, I think I've covered the core salient points on ground 3. When one looks at the judgment, when one stands back from it and looks at what the judge was looking at on Henderson and Henderson, on abusive process and on case management, one can absolutely see why the judge was entirely right to say whichever of these grounds you're looking at, there is no proper basis for repeating substantially the same infringement claims as were brought in the earlier proceedings, or certainly could and should. As I say, we didn't bounce the other side into court on closing down the liability phase. They had 18 months to lick their wounds and think about how they wanted to do it, and 2 months' notice that we were seeking final order to be entered. It's been entered, trying to open it up, not just at the beginning of the inquiry, 2 years later is one can see why the judge considered for case management for abuse of process, and of course for Henderson as well, why it shouldn't be allowed. There was one further point that I skipped over in my note that I just need to go back to, and this was the point where my learned friend was trying to say yesterday that all of this was already pleaded. The contention here is that the existing paragraphs of the pleading raise the issue of infringement of the IPC claims.
Well, so I suppose, formally speaking, question one under that head is, are you opposing the application to amend the grounds of appeal? And if you are opposing, on what basis?
No, I'm not opposing, my lord. I think your lordships have the points, and it's best that they're dealt with properly here. I will be slightly more, I won't be able to give you quite the assistance I would have given if I'd been able to deal with this and actually pull out the relevant documents during the on the points that I'm doing, but subject to my apologies to your lordship in respect of that. There's no prejudice to your lordships dealing with the point. So the first problem that my learned friends have with this is if they were right and the point was already an issue in a meaningful way, my learned friends wouldn't need their proposed amendment. Now, in fact, what we have in the Dr. Reddy's pleading is really nothing more than an introduction to the history of the case, against setting the scene against which it advances its inquiry. Now, my learned friends equivocated in their response, but no one thought that it mattered. I mean, if you read through my learned friend's defence, he equivocated at everything that was said in the points of claim. Each and every point was either embarrassing or was unclear or was badly pleaded. It's the most unhelpful defence one could expect to receive at that point in the action. But nevertheless, we've moved on. And what matters for present purposes is the case has been very heavily case managed. Both after pleadings in front of Mr. Justice Burse, he dealt with a couple of case management conferences. He set the case out into 3 separate trials over several years. It was subsequently re-managed by Mr. Justice Zacaroli after hearing the first counterfactual assumptions trial. And in addition to these trials, there's been lists of issues, there's been disclosure review documents, there's been consequential disclosure orders, and so on. This is a big case, and it's received huge amounts of time and effort, both from the court and from the parties. Careful and detailed management of a complex multi-party action. And nothing has been left to chance. At all times, it's been followed up carefully. Now, at no stage has anyone, including Warner-Lambert, suggested that patent infringement, and still less validity, is a live issue. There's been no disclosure, there's been no direction, there's been no pleadings, and there is no trial provision for patent infringement or patent validity. I mean, indeed, during the actual hearing before Mr. Justice Zacaroli, he made an order, and the relevant parts of it were settled before my learned friend started suggesting his pleadings supported his amendment application. And the order is at supplemental 14. Supplemental 14. Paragraph 1 vacates the common issues trial that was then set down, had been set down for some time. And then at paragraph 2, the order is a single trial to address all outstanding issues, including all issues relating to quantum, in all the inquiries listed for the first available and convenient date after October this year. Time estimate 25 days, 3 days pre-reading, 2 days to write closings, with a Chancery Category A and a technical difficulty rating of 1. It's got to have a technical category rating because we're in the Patents Court, but the judge specifically did a Chancery listing grade as well because we're in the inquiry. There is no suggestion whatsoever before my learned friend started moving his amendment application to say that patent infringement and validity was live in the inquiry.
What was the technical difficulty rating for the trial in the activist proceedings? 4, 5?
I don't know,
It was either 4 or 5. I can't remember which, but it was certainly one of the two.
but that would be my expectation.
For those of us that's me, not familiar with Chancery technical difficulty ratings, all the cases look difficult to me. Is 1 difficult or easy?
Oh, sorry, 1 is the simplest possible.
Yes, I see. So A is complicated for a Chancery category, but for technical difficulty, 1 is the
Yeah,
simplest.
that's specifically for proceedings in the Patents Court.
Yeah, I understand that.
1's as low as you can go. You're required to give 1, but the point that was being specifically made here is this is really complicated, 25-day inquiry, but it's got nothing to do with patents. You don't need...
No, I now understand the point you're making.
So we say, look, against this, against all the proceedings and the management up to date, and the order that was made at the very hearing where they were already thinking what their amendment application was that they were going to bring, even at that stage, there was no suggestion that it was live on the paper. But during the course of a 3 or 4 day trial, looking to see what could be said in support, the pleadings were scoured, and my learned friend started advancing a point that if you squinted hard enough, it was there and live on the pleadings as they already were. And we say, trying to rely on it now really doesn't assist the matter going forward.
So, can you just help us as to this? You accept that the point was raised before the judge.
Yes.
Judge doesn't mention it in his judgment. I'm speculating, or let me ask the question rather than speculate. Was there an extempore ruling by the judge in the course of the hearing saying, no, it's not been pleaded, and that's why you need to amend?
Not that I recall of. We can check the transcript. There certainly wasn't a judgment. He may have discouraged my learned friend from pursuing.
Well, because it seems a bit odd if the point was made as you accept, but it's nowhere dealt with by the judge.
My recollection of it, and it truly is my recollection rather than having read the transcript, is it was something that my learned friend lightly tried on in a series of various points. And I responded to it quite shortly with, come off it. And the argument didn't really go any further. And it's suddenly telling me, you don't find it in, my learned friend's grounds. You don't find it in his skeleton. Again, it comes back with full force. I think he was putting it forward as the strongest point on this appeal. And we say, look, it simply doesn't have the basis that my learned friend now likes to say it did. But we can check the transcript, my lord, to see if we can find anything.
My lord, I hate to interrupt my learned friends. They both sat there patiently every moment that I spoke. But I think it's being suggested that this order predates me raising that argument.
No.
And this is post the 4-day hearing at which on day 1 I raised this argument. And it's the same order in which the judge says we can't amend.
It is the same order. It was a multi-day hearing. The position on dealing with paragraphs 1 and 2 was settled before the amendment was. And of course, the judgment on the amendments followed some weeks, from my recollection, later, because it was reserved. So this order was done and entered, but as one usually does on a 3 or 4 day hearing, you move through the points and then the order gets made up at some later date and sealed. But we say, look, you would never have made this if it was being contended properly, that absent the amendments being allowed, there still needed to be a patent trial. there still needed to be patent infringement and validity. And as my lords commented yesterday, there certainly is no positive case of patent infringement.
All it pleads, if I've understood it correctly, is that it may have the inflammatory pain claims may have been infringed.
Quite.
That's not a plea that they have been infringed.
Quite.
It's just reserving. It's just reserving what is said to be an accurate statement of the position, but it's not advancing a claim.
It's a little like the point we looked at earlier, which is I say Warner-Lambert sent the threatening letters. They say admitted, but for point of clarity, it was Pfizer, but we take no point on it. It's a sort of discussion for discussion's sake. It's strictly absolutely right, but it doesn't give rise to any issue. And that's the way they've pleaded throughout their defence. My Lord Justice Arnold.
Yeah, so you mentioned the question of validity there, and I'm sort of just thinking that through. And as I understand your submission there, what you're saying is, and I just want to be clear about this, is that if any body had thought infringement is a live issue, it would automatically follow that the next thought would be, well, if infringement is an issue, we need to find out if validity is an issue.
Absolutely.
And so you would have been put to your election, were you going to challenge the validity of the IPCs or not? Absolutely. And if you did, there would plainly have to be provision for expert evidence and so on.
Absolutely. All the way through in the usual way. And my learned friends try to make something, what they say in their reply skeleton is they doubt you would bring a validity claim. It went all the way through to the Supreme Court.
But it didn't. Validity of the IPCs began and ended before me.
Your Lordship, that's the first point. Secondly, I'm not stopped. Thirdly, the fact that infringement went all the way to the Supreme Court is not discouraging my learned friends. We shouldn't be too surprised if I want to have a go at claims that really weren't the front and centre of attention in the Actavis proceedings previously. And then fourthly, as my lords will appreciate, and certainly my Lord Justice Nugee, I'm thinking of the Hoselock case, it wouldn't be the first time that one defendant failed and a subsequent defendant succeeded. It happens.
On different evidence.
Absolutely, my lord, on different evidence, but in circumstances where the focus of everyone's attention changes, I absolutely wouldn't rule out whether or not, a validity attack if we were facing a proper infringement attack. And I make the same point in respect of the order of Mr. Justice Burse, that had they have said at that point that as far as they were concerned, infringement allegations were continuing, the validity action that my client had pleaded, that all of the claims were invalid, would have been maintained. Now, it was in its early days and it mirrored the Actavis revocation action. It may have been, as is always the case, that the prior art changes, that other arguments of sufficiency or whatever they might be are raised, but certainly it would have been maintained until my client was satisfied that it didn't have anything meaningful to say on validity. But it was dismissed. Liability was over, both limbs.
Now we're coming up to 1 o'clock. You've dealt now with ground 3, I take it.
I've dealt with ground 3. I've got a short amount on ground 1, where your lordships will also want to hear, no doubt, from a learned friend, Mr. Campbell. I've addressed.
You may not want to.
I've already dealt with ground 2 in the appeal, so it's just me relatively shortly on ground 1, and then my learned friend.
Right, but that leaves enough time for the two of you to say what you need to say about ground 1, leaving Mr. Bolton. I think you agreed 30 minutes before we finished. Yes. All right. Unless what you have to say on ground 1 is limited to about a minute, we may as well adjourn there, I suspect. All right. Well, 2 o'clock.
Still 2 hours?